Hello, good morning, everyone. I hope you're all well. Welcome to the Faculty of Law 6th Annual Symposium on Law, Governance, and Society, Law and Justice in a Novel Era, Day 2. I want to welcome you to this panel that we will be hosting entitled The Development of Jurisprudence in Environmental Law. My name is Carol Excel, and I'm currently the Director of the Environmental Democracy Practice at the World Resources Institute in Washington, D.C. The World Resource Institute is a global environmental think tank that was founded in 1982 that operates all over the world, offices in United States, Brazil, Colombia, China, Europe, India, Indonesia, Mexico, in Africa, in Ethiopia and Kenya, with ongoing activities in over 50 countries around the world. Um, the World Resources Institute has a mission to move human society to live in ways that protects the Earth's environment and its capacity to provide the needs and aspirations of current and future generations. I want to thank the Faculty of Law for inviting me to chair this panel, and in particular, Lolita Davis-Mattis, my former mentor and boss at the Natural Resources Conservation Authority. It's really my pleasure to have such distinguished guests here today to talk to you about the development of jurisprudence in environmental law in Jamaica. I think before we get into the presentations, I just want to also mention that I'm a former graduate of the Faculty of Law. Recently, I discovered it's been 25 years since I've been called to the bar in Jamaica. And so I have fond memories of being at the Faculty of Law and being a lawyer in Jamaica, especially working at the Natural Resources Conservation Authority. And thus, I think that's why I've been asked to chair this panel, both having an international perspective and also a perspective on Jamaican law, especially environmental law. Clearly in Jamaica, there's been a lot of innovative judicial treatment on the environment, both through the use of the common law, the constitutional right to a healthy environment, which is in Article 13.3 of the Charter of Fundamental Rights and Freedoms, but also in relation to statutory law that exists on the environment. For example, the Natural Resources Conservation Authority Act, the Beach Control Act, Forestry Act, etc. But also really through the courts applying natural justice provisions, legitimate expectation, rights of a legitimate expectation, rights to a fair hearing, in trying to ensure that the law can be used successfully, both to protect the environment, but also to protect vulnerable people. So I think we'll have an exciting panel today to reflect on where we are in this journey of developing a strong jurisprudence. Quickly, as I was preparing for this panel, I took a quick look at some of the legislation, but also some of the case law coming out of Jamaica and the courts. And surprisingly, there's still not as much case law as there should be, I believe. There's much more that needs to be done by public interest lawyers and also lawyers in private practice, I think, to use environmental law successfully to achieve that result, the right to a clean and healthy environment. Many of the cases that have been taken over the last 10 years have actually been one or two plaintiffs taking many of the cases, although there's exciting new potential for litigation, I understand, coming out of the Public Defender's Office, and also some recent issues around environmental protection of endangered species, and also coastal issues that have also come before the courts. So I'm really hoping today that the panelists will talk about how environmental law can effectively be used to address the challenges, and what are those challenges that Jamaica is facing right now. Want to know about specifically whether or not litigation or use of law on climate change is something that is needed in Jamaica. Where do we stand in relation to addressing some of the hard challenges ahead for a small island developing state? Where many developments are quite controversial, where you have to measure the impact of the release of GHG emissions. Also very interested to learn more about thoughts about procedural rights, and thinking more about how the environmental law can protect the health of the most vulnerable. Also the use of civil and criminal law, and new issues of reform in environmental law. I hope the panelists speak about that. So today we're going to give 20 minutes to each panelist to speak. And we'll take questions at the end of the session after each one has spoken, and hopefully have a nice wrap up of what's in the future. What's the vision for the future of environmental law? So my first panelist is Professor Michael Taylor. He is the Dean and a Senior Lecturer at the Faculty of Science and Technology at the University of the West Indies. He specializes in the area of environmental physics, but also Caribbean climate variability and climatology and climate change. Recently, in an article, I noted he spoke about the fact that the pandemic might be a temporary reprieve on some aspects of the environment, but he hadn't seen significant inclusion of environmental concerns being discussed in relation to reopening, recovery, and living in the new COVID era. So I think he will give us a very exciting view on climate change, but also looking in particular, what does it mean in this novel area? So over to you, Professor Michael Taylor.
Okay, thank you. Thank you very much. I am really pleased to have been invited to be here. And I think, as you will notice, I'm kind of the odd person out, that in the sense that I am a climate scientist, and really what I'm going to talk about is climate science. And I think that what I've been asked to do, or why I have been invited, is to set a little bit of a context for some of the aspects of the discussion that you alluded to, and that will be followed up in many of the presentations here. And I really want to set this kind of context under the title that I have offered you. It's called Climate Matters and You. Very specifically, what I want to do is talk about 3 climate matters that are really emerging from the science. And it's a science that I know, not the law, and how they relate to you. And you as a Caribbean national, and you as well as a Jamaican citizen. Just to quickly begin, just to make sure we're all on the same page, when we're talking about climate change, we're really talking about these long-term changes in average weather patterns. And the most famous kind of knowledge of this is the global warming pattern. And if you follow it, clearly we have met some new records in 2020. But specifically, we're really talking about those changes that are due to human activity. And it is when you take this kind of look on climate change, long-term changes in the context of human activity, put that in the context of the Caribbean region, that I think when you do the science of that, 3 climate matters emerge. And I want to talk very quickly in my 20 minutes about those 3 climate matters and how they relate to you. All right, so 3 climate matters. What's the first of these 3 climate matters that emerge? And how does it relate to you? The first is what I call the matter of the unfamiliar. All right, so the first climate matter that emerges is the matter of the unfamiliar. Where do I get this from? I think if I were to ask any of you, how do you perceive climate change? There are a couple of things you would tell me. First, you would tell me it's hotter, and the science supports you in your conclusion. No matter what you use to measure heat, if you take, for example, hot days, you will notice straight across the Caribbean, those triangles are red and up, meaning it's statistically significant increasing, and you'll see the graph going up, and the number of hot days in a year have been increasing. Perhaps for us in the science, more striking is the number of hot nights, and those hot nights are increasing at a faster rate than the number of hot days. And if you put it together, we have seen about a 1 degree increase in Caribbean temperatures in the last century. And that 1 degree translates into 23 more hot days and hot nights since 1950. So you ask, where do those 23 days go? Well, summer starts earlier, it reaches these peaks and goes for longer. But I think you would also say, and especially in Jamaica now, that our rain has become way more variable. And the science is telling us that, listen, total rainfall in Jamaica over the very long term is more or less, is not getting wetter or drier. But if you look on the years, 1 year we are extremely wet, and then the next year we are extremely dry. And what you see is this very strong variability. And so we get these swings between extremes. But you'd also notice that the character of rain is changing. And so we get these very long dry spells, and then when it rains, it really rains. And so you would also say it's not only that it's getting hotter, but our rain is more variable. And this is something that's a little bit new to us. You'd have told me that the sea levels are also higher, and the science would support you. sea levels are rising at about the rate of 1.7 millimeters per year in the Caribbean, or post 1993 at about 3.5 millimeters per year. And yes, you would say millimeters per year, and I would say yes, that's what accounts for that favorite coastal spot of yours in Jamaica or anywhere in the Caribbean region, whether Little Ochi or Hellshire, where you can stand and say, I remember when that point in the ocean used to be on the land. And then I think you would tell me that we have seen more extremes. And we see it in many ways. One of the ways is clearly the Atlantic hurricanes are getting stronger, and the clear pattern of increasing the intensity is there. But one of the oft overlooked ways is the drought. And we have had two major region-wide droughts in the last 11 to 12 years, in 9-10 and 13-16. And if you count it, 7 of the last 12 years in the Caribbean have been extremely dry. We have been under drought conditions. And so we have seen more extremes. And the argument I'm trying to make is if you put it all together, the hotter the variable rain, the more extremes and the higher sea levels, what you see from the science is the emergence of a new climate era, where climate is not behaving as it used to, and it is marked by unfamiliarity. And the truth is, we're not getting one or the other. We're living in this multi-hazard environment. Why is this at all important? This is important, this matter of the unfamiliar, because Jamaica is extremely sensitive to climate, and the Caribbean region. It's almost inescapable in our daily physical life. Why? Where does the sensitivity come from? One, it comes from where we live. We're an island state. We have no mainland, other part of the mainland to run to in an extreme. Or we're an island state with narrow coastal plains and steep mountain sides. And so you either live on a steep hillside, which comes down, or you live on a coastal plain, which floods in a storm event. But it's not only because of where we live. Our life cycles are patterned after climate. And you can think about it. We plant and do agriculture around the climate. You know, we send children to school around climate. We don't want them in school in the summer when it's hot and them and the teachers are miserable. We clean drains. And you can see it. You can see it in your electricity bill, that kind of thing. Our productive sectors are dependent on climate. So things like agriculture and tourism, which are strongly dependent on climate. And then our kind of determinants, social determinants of good standard of living, health, energy, water, are intimately linked to climate. Put that together and we have a Jamaica that is extremely sensitive to climate. Well, if that is true, then you should quickly realize that Jamaica depends really on familiarity of climate patterns in planning. And so climate really makes, and because we depend on that familiarity, it makes climate a strong determinant of quality and standard of living. In truth, familiar doesn't mean good, but it means that even if it is going to vary, it must vary within bounds that we already know. So we depend on this familiarity of climate for development and for quality of life. Climate is introducing a new kind of unfamiliarity, and it's making development unreliable. So Jamaica's way of life is being compromised before our eyes, and climate is playing a big role. Just to make the case, I only need to put the headlines of the last 2 months up on the screen for you to see. And you can see that the sensitivity cuts across every part of life, and that sensitivity, which is embedded and pervasive across all areas of life, is now disruptive in this unfamiliar environment. So that first climate matter and how it relates to you. Listen, the science is saying that there's the emergence of a climate era marked by unfamiliarity. We are living in the era of unfamiliarity now. And in that era of unfamiliarity, Jamaica's quality of life is being compromised. All right, what is the second one? Very quickly. Why does climate matter, and why does it matter to you? Well, the second climate matter and how it relates to you is what I would call not just the matter of the unfamiliar, which we live with now, but it would be the matter of the unprecedented. And this is some of the science which I do. What I do as a scientist is that I take these computer models and I try to run them to the end of the century on the multiple storylines of best case scenario, worst case scenarios. And when I look at what we get, here is a picture of Jamaica at the end of the century and the region, even hotter times ahead. We have seen 1 degree now, up to 3 to 4 degrees by century's end on the worst case scenario, which is the top diagram, up to 98% of days being hot by current standards and only 2% being cool. That's unprecedented. What about that rainfall? Still variable, still a year with heavy rain and then a year with no rain, but varying about a lower mean. And so it's going to be up to 40% drier, shorter rainy seasons, longer, more severe droughts. What about those higher sea levels? Well, we move from millimeters to meter, up to 1 meter of rise by the end of the century. And those extremes, well, the top picture is the modeled category 4 and 5 hurricanes in the present. The bottom is the modeled category 4 and 5 in the future. Not necessarily more storms, but more intense storms. And I haven't spoken about the increase in the percentage of time in which we will be under drought. And the point that I'm really trying to make here is that when you look on the future Caribbean climate, it's going to look a lot different from what we see today. We see 1 now, but we're going to see 4. Variable now, but variable and drier. More extremes, but more intense extremes, 3.5 millimeters versus 1 meter. We're talking about the signs saying the possible future entrenchment of a climate regime marked by a climate we have not experienced yet. This is the sign saying we must take serious this matter of the unprecedented, which differs from the matter of the unfamiliar, which at least sometimes becomes familiar. Why again does this matter at all to me and you? It matters because we are getting a glimpse of the unprecedented already. Well, in 2017, we thought we had seen it all when we had 3 category 5 hurricanes in the Caribbean, Irma, Maria, Jose, in 1 season. But then came 2019, which was again record breaking. And that was Dorian and the fact that Dorian sat still. And then we said, well, we must have seen it all. And then 2020 so far, we have had 30 named storms. Again, this is the glimpse of the unprecedented that is to come. And the challenge with the unprecedented climate is that unprecedented climate equals unprecedented impacts. And the impacts span all areas of Caribbean and Jamaican life because the sensitivity spans all areas of Caribbean and Jamaican life. And so these become the scenes. But more importantly, maybe, any aspect of those development goals that we have signed on to that you can think of will be threatened under climate. And these are the goals that we are depending on to achieve for quality of life in the future and a proper standard of living. So you can look on the 17 development goals, and what will you realize? 16 of them will be impacted under unprecedented climate. Probably the only one that is not impacted is development goal 13, and that is climate action. So what are we saying? You know, I'm making a really simple point that it is, the science is saying there's not only the emergence of the unfamiliar now, this era, this new climate era that is marked by unfamiliarity that we have to live in now, which is already compromising development and therefore already compromising quality of life. But the science is saying, listen, we're heading for an unprecedented era, which we have not lived through yet. And that unprecedented era is already challenging Jamaica's development goals. And if we think we're going to achieve the development goals on the path that we are on, we are mistaken. So science is saying climate matters. And climate and the matters of climate that relate to you, the matter of the unfamiliar and the matter of the unprecedented. One more climate matter, because I know my time is going. Very, very quickly. You know, what is the climate matters emerging? It's the matter of the unfamiliar. Jamaica's quality of life is being compromised. What is the climate matter that's emerging? It's a matter of the unprecedented. Jamaica's development goals are being challenged already. And just to make a point that you can see the challenge that we're trying to live with the unfamiliar now, while at the same time we're supposed to be preparing for the unprecedented to come. But the third climate matter that emerges from the science is this, the matter of urgency. Why do I say that? Well, I can't be telling you what I am telling you and we sit back and do nothing. And there's a role for everybody. Why does it become an urgent issue? it becomes an urgent issue because in an era of unfamiliar climate and in an era of unprecedented climate to come, existing vulnerable groupings are expanding, their vulnerabilities are expanding, and new climate vulnerable groupings are emerging at a fast and furious rate in the unfamiliar and the unprecedented. Who are these existing, for example? Well, those are the coastal dwellers. And those are the people in Caribbean Terrace who, in the pictures here, who bought those lovely houses and thought they would retire with their coastal view. They are, and anybody even a little further inland of them, the coastal dwellers are among those whose vulnerabilities are expanding. It's also the farmers. And so when the science models where becomes good for agriculture in the future, you notice that the places that become good are the interior of Jamaica, which is our protected areas. And so the farmer on the south coast is among the vulnerable, but also the interior is amongst the vulnerable that is coming along stream. And then new climate vulnerable groupings are emerging. People like the poor who are disproportionately affected, elderly, children, any outdoor worker who needs to be protected, from security guards to tarmac workers, etc. Biodiversity, heritage sites which were never built to withstand an unprecedented climate, the future generation, climate refugees, people even in our country who are fleeing agriculture on the coast because agriculture cannot perform. But the other matter of urgency is simply our diminishing capacity to cope. If you look on Jamaica and how it has been impacted over the last 20 years, and the far right column shows the percentage impact of a climate phenomenon on our GDP. Can you see drought in 2000, Hurricane 1, flood 202, Charlie and Ivan in 4, Dennis and Emily, Wilma in 5, drought in 5, going down to May flood rains in 2017. And we have not put in 2019 yet. And look on the impact of GDP. It's not only the magnitude of the event, it's the recurring nature of the event as well. Every year we are dealing with a climate problem, and it is taking away percentages of our GDP that should be spent in other areas of development. And this will only continue into the future. And if we go to the 2008 study of Bueno et al. Looking on the future Caribbean, certainly by the time we hit the middle of the century, climate is costing us 22 US billion annually. And by the end of the century, 46 billion, and that was conservative estimates. 10% and 22% of the economy, the value of the economy at the time of the study. We have simply diminishing capacity to cope. That therefore gives us the urgency for action. Okay, so let me move to the end. What kind of action then? If there is a clear case for urgency of action in unfamiliar and unprecedented climate, then what kind of action? Well, the first is that we need a strong mitigation agenda. And the mitigation agenda is global, but it's also local. If we are to achieve the targets the Caribbean put on the table, CO2 emissions globally have to fall by 45% by 2030, and we have to reach net zero around 2050. Well, how do we mitigate? We need standards and regulations for energy. We need to deal with waste. We need to deal with protection for oceans and forests, which are our sinks for our carbon. And we need to urgently deal with transportation, and not just road, but also sea and air transportation. But it's not just so mitigation is reducing the greenhouse gas, and we need this urgent action across the region, and clearly we need action across the globe as well. But we have to deal with an unavoidable adaptation agenda. And the truth is that because of sensitivities across all areas of life, we need comprehensive and a range of appropriate adaptation options that we set the context for, we set on the table. They must account for the future challenges, but it also has to be consistent with the Sustainable Development Goals and recognize that there'll be synergies and trade-offs. So we need things, adaptation in the water sector, and we need it for infrastructure, whether hard defenses or soft defenses like mangroves. And we need it in the agricultural sector, and we need it in the building sector, and we need it with protection policies and zoning about where you can live. And we need alternative livelihoods for those sectors. And I can go on and on. I haven't talked about health and finance, etc. But we need an unavoidable adaptation agenda. And then the third action, we need a sustained education agenda. Because it's only education, and this is a great conference that puts a climate scientist to talk that, that at least is dealing with education. We need conscious, convinced, and convicted people, but it only comes through education. But education has to be premised on transparent and equitable access to information by all who have to make a decision, and all includes me and you, because information in the hands of some will certainly cause disadvantage for the others. So let me end then. Where am I going in my end? The pathway to resilience is mitigation, adaptation, and education action, because that's only what can take us to resilience in a climate that is unfamiliar and that is unprecedented to come. Where do I think the intersections are with the law of alternative not being a lawyer? Well, if you listen to these arguments for mitigation, adaptation, and education, clearly regulations and standards. And that has to be critical, especially when you begin to talk about mitigation and us participating in mitigation. Where do I see the thing? It's advocacy and negotiation on behalf of the vulnerable, whether the vulnerable within our country or the vulnerable as a country as a whole. It's an enforcement and accountability. That's the only way adaptation is going to work and work for all. And I would argue it's in novel laws and an agile, responsive legal system. Climate is introducing new things, and we need new mechanisms to deal with climate. And we need systems that are also responsive. So I end. What are these climate matters? And the climate matters, and how do they relate to you? Very simply, it's the matter of the unfamiliar, this new unfamiliar era where Jamaica's quality of life is being compromised. The matter of the unprecedented, where Jamaica's development goals are being challenged, and the need for climate action to ensure a livable future. That's a matter of the urgent, because Jamaica's future viability then is in our charge. And if you want to know why climate matters to you, it's those reasons. Compromised quality of life, challenged development goals, but the fact that we can have a future, but it's in our charge. Thank you very much.
Thank you very much. And I'll give you a round of applause, Professor Taylor. That was wonderful. You raised such important issues, the extreme sensitive nature of Jamaica, climate sensitive nature of Jamaica, the dependence we have on our quality of life on having a good climate, or a climate that's not compromised. And you talked about an agenda for urgent action, mitigation and adaptation. You provided a lovely reference to the importance of equitable access to education as a critical part of that agenda. And so I hope the other panelists can live up to the kind of charge that you have set us all. And if you're not interested in climate before, I hope you're really interested in what agendas on climate are being taken on by the Jamaican government and people and civil society, because you certainly have raised it as a huge issue that we need to consider what role law can play, especially in the enforcement and accountability, the protection of specific areas, protection of the ocean, etc. So thanks so much for that. Our next speaker is Mrs. Lalita Davis-Mattis. She's a university counsel at UWI-Mona. She also serves as an adjunct lecturer to both the Faculty of Law and Faculty of Science and Technology, where she teaches international and Caribbean environmental law and policy for natural resources management. She was the former executive director of the Jamaica National Heritage Trust, and she's had in that position that she played many years. She has been really successful in, really raising the agenda about the connection between the natural heritage and history. And I note that she also was very instrumental in the declaration of the Blue Lagoon as an area of national heritage. She's now being very much involved in discussions around reparations. So she's very diverse and talented in all the work that she has done over the years. And she was, as I mentioned before, she was my former boss at the Natural Resources Conservation Authority in environmental law. Lalita, I want to put the floor over to you. I'm really excited to hear about your views about the Escazú Agreement and other views around citizen participation. It's an area of work that I'm now focused on in my work. on the rights, procedural rights of citizens and what role they play. And so please, over to you.
Thanks a lot, Carol. And thanks, Prof. Taylor, for laying the foundation. I think one of the things that came after Prof. Taylor's presentation has to do with the role of the state, which is basically the essence of my presentation. And I want to start by speaking to the notion of the right. In other words, so we're talking about climate change, we're talking about protecting the environment, but is there a right to a healthy environment? And I want to start by just talking about the right to development, which actually is an inalienable right. And that is a right that is the purview of states. And I know that we are having many conversations. Professor Taylor talked about, what are the issues that we need to deal with just going forward as we address climate change, which for all intents and purposes, basically has been determined to be the most pressing threat to the evolution of humanity. So what is this right to development? And I want to just refer to the Declaration on the Right to Development, and that was a General Assembly declaration from 1986. And it says it is an inalienable human right by virtue of which persons and all peoples are entitled to participate, and I'm highlighting some words here, all peoples are entitled to participate in and contribute to the economic, social, and cultural, political development in the space in which they are in. And the human right to development also implies full realization of the right to self-determination, and that includes provisions at both international covenants and human rights, etc. And of course, as we said, it is an inalienable right. Now, the human person is a central subject of development, and as we see how we have managed this planet, we will recognize that we are the problems. I usually say to my students, take us out of the issue, take us out of the environment, and the environment is fine. And Professor Taylor also mentioned, I think Carol mentioned it in the beginning of her presentation, that the world is seeing where, because of COVID, unfortunately or fortunately, that in parts of the world, the environment is really thriving more because basically we are kind of out of the picture. But at the end of the day, we have to regulate behavior. And so states have a responsibility to create national and international conditions favorable to the realization of the right to development. And I want to just ask us to put that in the back of our minds as we talk about the right to development, especially as we address many of the issues we're addressing in Jamaica today. We're talking about Rio Bueno, we are talking about the cockpit country. Professor Taylor spoke about the issue of poverty, about all these development goals. How do we fit all of that within this context of the right to development and the right of the state to ensure that we all live in an environment that is commensurate with proper human health and living? So is there also a right to a healthy environment? So this right, even though not enshrined in any one global treaty, it has been enjoying global application and has been recognized in various forms, regional agreements, and in most national constitutions. And Carol mentioned the Escazú Agreement, which I'm going to be addressing later on in the presentation. So state responsibility towards fundamental rights and environmental justice. So it is translated to the development of legislation and policies. And today, more than 3/4 of the world's national constitutions include explicit references to environmental rights. And as we speak to the development even of regional agreements, we'll talk about the right and the right to access to justice and how that is intended to play out so that we can resolve many of these other issues that we have in terms of the extent to which members of the public have a right in decision-making and the right of the state, or rather the obligation of the state, to explain itself to members of the public when adverse decisions are being made that perhaps are adverse to the public or adverse to the environment. And I want to also pause here to say that as we talk about the development of legislation, many of the laws that are being developed actually are very explicit in terms of when you grant or don't grant a permit. And I want to say specifically in the case of Jamaica, under the Natural Resources Conservation Authority, that is very clear. It says, where the authority is of the view, and I want to also underline of the view, that the activity in question is likely to be, and we'll find those words in environmental laws, and therefore the jurisprudence will also add to that. It said where it is likely to be injurious to the environment or public health, then that permit should not be granted. That is very clearly stated in the legislation. How we interpose that within the context of the right to development is a matter for the public and the state and the regulatory agencies. So I want to just mention here the concept of sustainable development. And this is coming out of the Brundtland report, which came out in the early 80s when the world recognized that we are really the architects of our own demise in terms of how we are addressing the environment. And it says, the concept of sustainable development, it does imply limits, not absolute limits, but limitations imposed by the present state of technology, social organization and environmental resources, and the ability of the biosphere to absorb the effects of human activities. But technology and social organization can be both managed and improved to make way for a new era of economic growth. And the commission, which is the Brundtland Commission, believes that widespread poverty is no longer inevitable. Now, based on this was 1982, based on Professor Taylor's discussion and looking at the development goals, he mentioned that poverty in terms of climate change and all the impacts, perhaps, I'm not sure if we can now say that widespread poverty is no longer inevitable. Now, poverty is not only an evil in itself, as we all know, but sustainable development requires meeting the basic needs of all and extending to all the opportunity to fulfill their aspiration for a better life. So how do we do that within the context of this right of the state to development and the right of the state to manage its resources based on its own policies? And when we look at the international agreements globally, we recognize that these are terminologies and these are provisions that are incorporated in almost every single international treaty. I want to also note here that in the end, sustainable development is not a fixed state of harmony. It is a process of change in which the exploitation of resources, the direction of investments, the orientation of technological development and institutional change are made consistent with future as well as present needs. And as we go into the discussion, we'll recognize that even the notion of future needs and future generations yet unborn, that there also is a right for future generations to approach, as we will see, the courts to determine what their rights are. And it says here, painful choices have to be made. So in the final analysis, sustainable development must rest on political will. And of course, we have noted that climate change is the biggest threat to our survival, species, and is already threatening human rights around the world. So I'm going to pass by the Paris Agreement, and we know that that's the most recent agreement coming out of the Climate Change Convention. And Jamaica has indicated what its nationally determined contributions will be in terms of meeting the climate goals. So what are some of the problems with environmental harm? So environmental harm interferes with the full enjoyment of a wide spectrum of human rights, and also the obligations of states to respect those rights, to protect those rights from interference, and to fulfill human rights in the environmental context. And that is very, very important interface. The continued ecological viability, as we know, of our planet has been called into question. Professor Taylor's presentation, I won't complete the slide, basically has spoken to that. And we know that civil society organizations have been very active in consistently voicing their concerns with respect to environmental rights, and also have been representative of those vulnerable populations. The problem with the right, though, and I want to just give a humorous example from, again, in early 1970s here, where a group of prison inmates in Suffolk County Jail tamed a mouse that they discovered, and they gave him the name Morris. The jailer, having discovered Morris, flushed him down the toilet, and the prisoners brought a proceeding against the warden, complaining that Morris was subjected to discriminatory discharge and was otherwise unequally treated. The action was unsuccessful on the grounds that the inmates themselves were guilty of imprisoning Morris without a charge, without a trial, and without bail, and that other mice at the prison were not treated more favorably. Now, what is the significance of this? Because when it comes on to determining rights for natural objects, there is always a a debate. Do trees by themselves have rights? Does the river have rights in and of itself? What value do we place on the natural resources that determine how we actually treat with them? So segue into the development of environmental law and environmental jurisprudence. This era of law has really evolved to unprecedented levels of innovation, and to the extent where the courts, the judiciary, has also been very innovative, as Professor Taylor also mentioned in his presentation, in how they have interpreted international norms as well as local legislation. And this is just a quote from the judge's declaration out of Johannesburg in 2002. And it says here, the human right to a healthy environment brings together the environmental dimensions of civil, cultural, economic, political, and social rights, and protect the core elements of the natural environment that enable a life of dignity. And it goes on to speak to the role of the judges in interpreting the rule of law. So here you have a judiciary that is cognizant of and sensitized to the issues relating to the environment, the issues relating to human rights, and even where they are not so enshrined in legislation, the courts have really taken a very proactive view. And of course, we speak about the issue of the constitutional rights not being enshrined in the legislation. So for Guyana, just some examples. In Guyana, the Constitution provides that in the interest of the present and future generations, the state will protect and make rational use of its land, mineral and water resources, as well as its fauna and flora, and will take all appropriate measures to conserve and improve the environment. And of course, Article 25 also places a responsibility on the citizen and provides that every citizen has a duty to participate in activities designed to improve the environment and protect the health of the nation. Over to Jamaica here. Our Charter of Fundamental Rights and Freedoms now speak to the horizontal enforcement of rights. And it says here, we have a right to enjoy a healthy and productive environment free from the threat of injury or damage from environmental abuse and degradation of the ecological heritage. I just want to mention a few. Haiti says there's a right to life and health, and places on the state the obligation to guarantee the right to life, health, and respect of the human person of all citizens without distinction. And I want to point out here that in many jurisdictions, the right to life is now being construed to equate to a life to a healthy environment. So even where there are no constitutional rights per se, the courts are now interpreting the right to life provisions to include a right to a healthy environment. In Cuba, the state recognizes the close links with sustainable economic and social development to make human life more rational and to ensure the survival, well-being, and security of present and future generations. And you'll see the words future generations being a part of all the international discourses as it relates to the environment. And so this is the generation not yet born. In the interest of time, I just pass over some of them, but just to mention, for DOMREP, every person has a right, both individually and collectively, to the sustainable use and enjoyment of the natural resources, to live in a healthy, ecologically balanced, and sustainable environment for the development and preservation of the various forms of life, of landscape, of nature. And we could go on. And on. When it comes down to South America, for example, the provisions are very interesting. For example, in Bolivia, there is a law that's called it's called Mother Earth. And in that legislation, it is the earth that's actually given the right. And then it is a human interface that is to enforce the rights of Mother Nature rather than the other way around. And that's also very interesting way to look at it. Now, some of the legislative interventions that we see here, the prevention of harm should be the court's primary objective wherever possible, especially where there's a constitutional or legislative obligation to protect the environment. The principle of prevention will most likely necessitate injunctive relief where the threat of harm is imminent or harmful activity is ongoing. In Trinidad and Tobago, for example, the issue of public consultation, in this case, Talisman Petroleum Limited and Environmental Management Authority. And the court held that public participation is important. It improves the understanding of issues among all parties, finds common ground, and determines whether agreement can be reached on some issues. 3, highlights trade-offs that must be addressed in reaching decisions. And the court held it is not a mere formality. Consultation is not a mere formality, but a process that allows the public to have a reasonable and sufficient opportunity to review, consult, and comment on a specific decision. In a case coming out of Canada, the Queen and the United Canada Mines Limited, the court held that pollution is a crime. Seemingly small consequential acts of pollution are cumulatively imposing extensive tangible social costs. Pollution offenses must be approached as crimes, not as morally blameless technical breaches of a regulatory standard. In terms of standing, the issue of standing, of course, we all know as attorneys, has to do with how do you approach the court. But we know, for example, that in the case, for example, of children, they come by next friend. So in terms of the environment, what do you do? If the environment is being harmed, who is it that can bring this action? So the critical question of standing, this is Justice Douglas in a famous case in the 1970s in the US. He had a dissenting judgment. He said the critical question of standing would be simplified and also put neatly into focus if we fashioned a federal rule that allowed environmental issues to be litigated before federal agencies or federal courts in the name of the inanimate object about to be despoiled, defaced, or invaded by roads and bulldozers, and where injury is a subject of public outrage. Contemporary public concern for protecting nature's ecological equilibrium should lead to the conferral of standing upon environmental objects to sue for their own preservation. And in this case, he said the suit would properly be labeled Mineral King, which was a valley, Mineral King Valley, and Morton. And so this is 1972, but the jurisprudence really has developed, and I would say really rushed ahead in terms of compared to other areas of law. In this case, coming out of the Philippines, the case was whether the petitioners who were minors had a cause of action to prevent the misappropriation or impairment of the Philippine rainforest. The complaint was instituted as a taxpayers' class action suit, and it alleged that the plaintiffs were all citizens of the Republic of the Philippines, taxpayers, and entitled to the full benefit, use, and enjoyment of the natural resource treasure that is the country's rainforest. So the court held that it was a class action suit and it was of general application and interest to all citizens of the Philippines. And it says it was impractical, not impossible, to bring all of them before the court. And so the plaintiffs were so numerous that the court gave standing to the group, and also held that generations not yet born could also be represented by this group of persons. So the current generation, which we call the intra-generation, can represent the intergeneration, which would be the generations yet unborn. In the Queen and Panarctic Oils Limited, the court said, in my view, the destruction of any ecosystem or environment is a gradual process, effected by cumulative acts, a death by 1,000 cuts, as it were. Each offender is as responsible for the total harm as the last one, who visibly triggers the end. The first offender can't be allowed to escape with only nominal consequences because his input is not as readily apparent. In our Petrie Bottom case here, a few years ago, famously called the Petrie Bottom case, Justice Sykes, as he then was, said, I would have thought that if an EIA, an environmental impact assessment, is going to be done for this area, it would require as much current detailed information as possible. The importance of accurate information is hard to overstate. It is the information provided that is going to play a large part in the decision-making process. There is no doubt that in the decision-making process, the EIA produced by the developer goes a far way in providing a factual basis for any decision made. No one has contended otherwise. So here we have, and I've really just touched on just a few issues, but I just want to mention here, help is on the way is what I call it, based on the regional agreement and access to information, public participation and justice in environmental matters in Latin America and the Caribbean. ESCAZO, very important agreement, and I just want to highlight here some of the obligations that is imposed on states. Now, Jamaica has adopted the text. We have not yet ratified, but it is my understanding that the country does intend to ratify the agreement. So what are some of the obligations? Each party shall guarantee, and I want to say Carol was a part of these negotiations. The terminology used in this agreement is basically a little different from that which is used in many other international agreements, because the language is not so nebulous. It talks about what you shall guarantee. It's not talking about as far as it is practicable and words like that. It's talking about guaranteeing, is using the word shall, making the terminology mandatory. Each party shall guarantee the right of every person to live in a healthy environment and any other universally recognized human right related to the present agreement. Each party shall seek to adopt the most favorable interpretation for the full enjoyment and respect for the access rights when implementing this agreement. I'm going to be rushing through this. I know time is upon me. Each party shall ensure the public's right of access to environmental information in its possession, control, or custody in accordance with the principle of maximum disclosure. And yes, we may say we already have an Access to Information Act, and that you can always go to that body to get information. It says the competent authority shall guarantee that the environmental information is provided in the format requested by the applicant, if available. If such a format is not available, the environmental shall be provided in the available format. It talks about ensuring that consumers have official, relevant, and clear information on the environmental qualities of goods and services, their effects on health, etc. So we're talking about imposing labeling standards, ensuring that if the product contains genetically modified organisms, for example, that you must encourage public and private companies, particularly large companies, to prepare sustainability reports. So that's not imposing on the private sector. And of course, that can be done by regulation. Public's right to participate, to implement open and inclusive participation in decision-making. Each party to adopt measures to ensure that the public can participate in the decision-making process from the early stages. Why? So that due consideration can be given to the observations of the public. And of course, this goes back to Chief Justice Sykes' statement in the Petrie Bottom case about even the notion of an environmental impact assessment, that it should be robust enough and substantive enough so that the public can understand, and so that the decision can be made based on the environmental impact assessment. And each party shall ensure that once a decision is made, the public is informed in a timely manner thereof of the grounds and reasons underlying the decision, including how the observation of the public have been taken into consideration. Again, guarantee rights of access to justice. This was a big issue because we understand, for example, that when it comes down to judicial review, many of these are taken by the non-government organizations, which have to source funds elsewhere. Carol spoke earlier about the role of attorneys, perhaps in even pro bono work, in seeking to ensure that we all have a right to this environment. Each party ensured in the framework of its domestic legislation, access to the framework of the access to judicial and administrative mechanisms to challenge and appeal with respect to substance and procedure, rights of access to justice, and therefore competent state entities with access to expertise in environmental matters. These must be made available to the public. Effective, timely, public, transparent, and impartial procedures that are not prohibitively expensive. This was also a critical part of the negotiations for this agreement, because we all know that legal fees are not necessarily affordable by all, and that in many instances, persons who are impacted by environmental indiscretion are people who are what we call the vulnerable communities or the poor. Broad active legal standing in defense of the environment in accordance with the basic legislation. So it's basically asking the states to basically enact legislation that allows this kind of access. And in the region, we do have some legislation. For example, in Trinidad and Tobago, you do have access rights for persons who want to ensure that a permit or a term of a permit is being adhered to. And there's a process for that. The issue of ordering precaution and interim measures that would include injunctive relief, mitigation, and so on. So basically, the legislation has moved, and the legislation itself is granting the access issues. The legislation is addressing the standing issues. The legislation is addressing the pollution issues. We talk about lifting the corporate veil in many of the environmental laws. They speak to if a company, for example, is found guilty of an offense, then it goes down to the directors and the agents of the company, and it makes them liable. In some of the legislation, you have a defense. In some, you don't. Strict liability offenses offenses that import mens rea, that speak to knowingly causing, etc. The courts are now saying no, because it is too difficult on the prosecution to prove. And that therefore, even where the statute imports mens rea, the courts are considering that to be strict liability offenses. So I just want to stop here, because I know that between Philip and Jeremy, they will delve more into the case law and into the legislation. And I stop here and I thank you very much.
Thank you very much, Lalita. Thank you for your wide-ranging presentation that even spoke about the rights of nature, going into more detail about the use of the law and citizen empowerment to use the law successfully to engage in environmental matters. I know that we're running a little bit behind time. I know we also started late. So I'm just going to jump into the introduction of our next presenter. Just briefly to introduce him, to say our next presenter is Mr. Jeremy Taylor. He's the Senior Deputy Director at the Office of the Director of Public Prosecutions. He's done a wide range of work at looking at improvement of the judicial system. I know that years ago he was also involved in exchange programs to look at improving the functioning of the judicial system. I'm really interested to hear his comments about environmental law and the ability of the court to hear such cases, and also some examples of some of the work that has been done recently to engage on the criminal law. So he also has a last name very similar to a previous panelist, and maybe at the end you can ask him about what that connection is. Mr. Taylor, it's over to you.
Yes, thank you very much for the invitation. I will start out with the usual disclaimer. Opinions expressed here are not necessarily those of the Office of the DPP or those of Ms. Paula Llewellyn. They are entirely mine, so if any offense should be taken, please take it with me and not the office. I am also the only non-environmentalist here on this panel. I am not even a talented amateur, so please forgive me if some of the conclusions I draw are incorrect. And thirdly, I just want to thank Philip Cross. I plagiarized from a presentation he made to our office, shamelessly so, in some parts of this presentation. So I hope you are able to see the presentation. Is it up yet? Yes. So I have entitled it Too Little Lizard, because every good presentation should have a little bit of controversy. And for those of you in the environmental field, you know where this quote comes from. Because there's a large number of legislation in Jamaica dealing with environmental protection, I've decided to filter them through the prism of one, and that is the Fisheries Act and some related legislation to fisheries. Because the Fisheries Act is new. It was passed in 2018 after gestating for many years. I want to begin by stating 4 presumptions about the environment, and this is one of these opinions for which I have given a disclaimer already, but I have identified 4 presumptions about the environment in Jamaica. 1, Jamaican politicians and commercial elites have long regarded undeveloped green spaces as an anathema. Every green space must either be dug up or built upon, otherwise such land is a wasted resource. Number 2, it has a capacity to embarrass governments of Jamaica, although it doesn't have the accompanying electoral consequences. 3, and based on recent events, we are going to enter a usual period of anguish and hand-wringing when we give thought and consideration as to the efficacy and efficiency of Jamaica's environmental enforcement mechanism. And 4, and I must confess, that on the criminal side, there is hardly any jurisprudence on the higher courts on environmental offenses. So far, the only one that I've been able to find is York Seaton against the Queen, touching and concerning the hunting of ring-tailed pigeons. The only one I found that has gone to the Court of Appeal. But notwithstanding that, if you go back into the history of Jamaica, you will actually see that there is some legislation, again, being filtered through fisheries to protect resources. So I've extracted some. So there was legislation on fish pots, and this was about the 18th century. And then also in the 18th century, there was legislation about poisoning or putting substances in fish ponds or harbors and so on to catch fish, and the size of nets and so on. And you can see if you were a slave, you would get 30 lashes. And if you were a free person, you get 40 shillings. And there was also, importantly, again, also in the 17th and the 18th century, legislation to protect the eggs of nesting turtles. And it's because in the 17th and 18th century, Jamaica actually used to supply turtle meat to passing ships and so on. It was an important trade. So there was legislation designed here to protect the economic activity. And I couldn't resist, I had to put this one in here, that in 1687, there was Law 54, a law which protected jonquils, that you couldn't kill them. And if you did so, you would forfeit £5, half of which would be given to the person who brought the case. And there would be forfeiture on your goods. And it's because of the status of jonquils in cleaning of carrion and dead flesh on the streets of Jamaica. So the criminal law has been there in protecting the environment. And if you go to the Constitution guarantees a healthy environment for all. And while many rights are filtered through the abuse of the criminal law, it should also be noted that the criminal law is there also to enhance these rights and fundamental freedoms of the people of Jamaica. So when we come to Jamaica, you will find that there are quite a number of laws. As Sir Thomas More said, this country is planted thick with laws from coast to coast. And the laws span a mixture of both the common law and statute law. So I've tried to highlight some of them. I'm not going to go into any great detail because I know my time is limited. So you have like the common law of public nuisance, which can be used and omission to carry out a legal duty in regard to life, health, property, morals, or so on. Some nuisance laws have been reduced to statutes, for example, in public health statutes, public health regulations. But if you go by common law, the penalty is greater. It's 2 years imprisonment and about $1 million. Whereas I think if you go by the statute, it's probably just about $50,000 or so on. And there are quite a number of statutes. I start from the first in the Town and Communities Act, all the way down to the Ballast Water Management Act of last year. And these are some selected regulations, protections of watersheds, beach control, fishing industry regulations, public health, nuisance regulations, many under the Natural Resources Conservation Authority. The Trade Act dealing with scrap metal, endangered species conservation and regulation of trade regulations, wildlife protection regulations, and the most recent plastic packaging materials prohibition order. So we have all of these statutes. So it cannot be said that there aren't any laws covering a wide area of environmental enforcement in Jamaica. The issue has always been, yes, we have the laws. The issue has always been enforcement. Why aren't these laws being enforced? And the most common types of environmental offenses, and I'm grateful for Philip for these because Philip has gone into court far more often than our office has in relation to environmental offenses, at least when he was with NEPA. So it's usually pollution, it's usually illegal bird shooting, illegal fishing, and protected species. So the presentation asked me to look at pathways and highways to environmental protection. As I said again, to remind you that I have looked at it through the prism of the Fisheries Act, because it is very new legislation to see where is the government going, where would prosecution go if these laws were to be enforced. So we start off with the whole issue of mens rea and strict liability. Your standard criminal law is that in addition to committing the act, you must have the guilty intention of doing it. You must have had the intention to commit the wrong. That's the nature of crime. With environmental offenses, if you were to try to prove the guilty knowledge of the accused persons, many of these offenses would fail. And Lord Bingham, Lord Chief Justice of England, had said so in Milford Haven Port Authority case, 2002 Criminal Appeal Report sentencing at 423. And he sets it out as to the reason, the ratio legis for strict liability legislation and why the departure is necessary. And challenges have been made, and they have strict liability legislation has been found to be constitutional. So, for example, pollution type legislation like Section 94, one of the Fisheries Act, placing or causing to be placed a poisonous or noxious substance in a fish sanctuary. If you go by cases like Alpha Cell and Woodard, which is a river pollution case from United Kingdom, decision of the House of Lords. The House of Lords looked at the cases, especially talking about causing that there's no mens rea requirement, because the defense was that they couldn't be prosecuted for this because they didn't have the mens rea to pollute the river. And at the very least, the prosecution should have found negligence before they could be convicted. And the House of Lords said, no, causing is to be given its ordinary meaning. It happened, you people caused it, whether it's by accident or so on, but it happened, that is it. There's no need for due diligence, there's no need for negligence. It's only an act of God or third party that creates a defense. So this is one of the so the Fisheries Act retains strict liability. So you will find throughout the Fisheries Act terms such as damaged, failure, using, engaging in, possession of, without any kind of qualification such as willfully or knowingly or so on. There are some provisions which have that, but for the most part, there are strict liability offenses in the Fisheries Act. So this is a good thing. So it's a good thing that Parliament did when in the Fisheries Act, they made most of the offenses strict liability. The other good thing that has been passed is in an amendment to the Evidence Act in 2015, Section 31 CB1, which now allows for, once you serve it within the requisite period of time, expert reports to be admitted into evidence without calling the expert to come and give evidence. We have found this provision very useful in criminal prosecutions, such as murders and rape, where we serve these reports without having to go and call the experts to give evidence once you go within the statutory time limit. Because under the previous dispensation, it was really only Section 50 of the Evidence Act, which allowed for medical reports, now repealed. So therefore, the report couldn't come in. Every lab technician, every scientist had to come to court and to testify and to subject themselves to a lot of long cross-examination. However, the court can, in the interest of justice, still call these experts to come to court. But no, they really can now be tendered once you serve through the statutory time limit. The Fisheries Act adopts two important principles of environmental law and management, although they don't define them in the Act. It adopts the precautionary principle in Section 4C and the user pays principle in Section 4F. So it says the precautionary principle shall be applied, and it doesn't qualify it. So that's it. So it sets in an absolute term. Whereas for the user pays principle, it says it shall be applied where applicable. So I found this case on the precautionary principle. It's an Australian case, Telstra Corporation Limited against Hornsby Shire Council. 2006, New South Wales Land and Environmental Court 133 at paragraph 113. It's on the OSLE website, so it can be accessed and you can look at it. It's a very useful judgment because it goes through what is the foundation of the precautionary principle. And it says it's not necessary that serious or irreversible environmental damage has actually occurred, that it is likely to occur. Now, I heard Mr. Davis-Matt say that this is actually in the NRCA Act. So it's good to see that in other pieces of environmental legislation, that this principle is also being expressly stated, although I think it is interesting to note, again, an opinion for which you can't hold Ms. Llewellyn responsible, that no doubt the NRCA report in Dry Harbor relied upon this principle, but the parliament that enacted it also saw it fit to go behind it and not to acknowledge it. If you look at this principle, Preston CJ goes on to speak about what are some of the things that you take into consideration. Let me also try to rush through the rest. So there's also a broad definition of fish, which is also a good thing. It has 8 evidential presumptions, which now must be rebuttable on the part of the accused person. Although the prosecution still retains that they still need to prove it beyond a reasonable doubt. So I'm not going to go through all 8 because the time is there, but you will all get the presentation, no doubt. So, but there are these 8 rebuttable presumptions. And then another good thing is that there are sentencing guidelines for the environment. And these come out of the sentencing guidelines out of England, out of their sentencing guidelines. And I think our sentencing guidelines may come to be reviewed quite soon. And it is quite possible that when it comes to be reviewed, they will include sentencing for environmental offenses. So it starts with a culpability index, ranking them from high deliberately, then number 2, recklessly, negligently, and then lower, no culpability. It looks at aggravating factors and it looks at mitigating factors. Now, can't leave without speaking about some of the potholes in criminal environmental enforcement. We legislate in silos. That is meaning that when we pass legislation, we don't look to see how it affects other related legislation. And this is a case in relation to the Fisheries Act. So there were no consequential amendments to the Wildlife Protection Act and Exclusive Economic Zone Act in relation to penalties. And the Endangered Species Act does not even have illegal possession provisions. And then you have some inconsistent provisions in the Fisheries Act, mens rea versus strict liability. So in section 89(2), you would have to prove mens rea, possession of fishing contravention the provisions of this act, versus section, I think this is 91 thing there, in which is strict liability in relation to possession of fish, even though both of them carry the same penalty. We don't know why there is this inconsistency between the two. There are reduced penalties. For example, in the 2015 amendment to the then Fishing Industry Amendment Act, the Supreme Court penalties were high, with at least 5 years imprisonment. By the time the Fishing Industry Act was repealed and the Fisheries Act of 2018 was enacted, those 5-year penalties in the Supreme Court had been reduced to 2 years. There is no reason for that. And then the flagship legislation of environmental legislation in this country, still after all of these years, the maximum penalty is $50,000 or 2 years imprisonment for very serious environmental offenses. I just want to mention these unfortunate repeals before I close off. So under the Fishing Industry Act, you had a provision for carrier vessels, and it was a useful provision because it set out terms and conditions of work in relation to health and safety of the workers on those vessels. Has been repealed. Perhaps they're going to come in regulations, but there's no reason as to why it has been repealed. And the other repeal under the Fishing Industry Act was that Section 25 had a provision which had a fine of $1 million or imprisonment for 6 months if you breached the regulations. When the Fisheries Industry Act was repealed and the Fisheries Act was reenacted, there was no provision for section 25.2, which means now you go back to the default position of what the original penalties were. So immature conch, you drop from 1 million back to 1,000. Buried lobster, $500 or 6 months imprisonment. And so these are some unfortunate repeals. There's no procedure for forfeiture in the Act. The fishing industry, the Fisheries Act has not addressed the status of the Morant and Pedro Keys, which are important fishing grounds in Jamaica. And I'm going to wrap up by giving you these those are the offenses. I'm going to end by sounding a warning. If you look at these quotes taken from the history of the fishing industry in Jamaica, you will see that in the 1680s, we were talking about abundance of fishing in Jamaica. It's in a place where great freshwater and sea fish is down in the island and around Jamaica. 1680, 1815. But by the time we come to the 20th century, the quotes are saying by 1945, 50 or 20 years ago, fishermen got as much from 6 fish pots, now they get from 15 or 20. And then by 2003, the reef fishery on the north coast of Jamaica is one of the most overfished in the Caribbean. So there is some good under the Fisheries Act, there is some bad under the Fisheries Act, and it kind of represents how legislation is approached in relation to criminal penalties in Jamaica. I want to just end by saying, if people are dissatisfied with the way how the prosecutorial authorities may have to approach some of these offenses, please know that the law has not repealed private prosecution for these offenses. And ladies and gentlemen, thank you very much.
Thank you very much, Mr. Jeremy Taylor, QC. I think that was a very challenging presentation, very comprehensive, and I would dispute that you're not an environmentalist, both with how you started and how you ended that presentation. There's a huge challenge to address the needs to address the wide range of overfishing that happens in Jamaica, and it's been a long-standing issue that I don't think has yet been resolved. And maybe continuing a task force to look at some of the issues you raised in your pothole presentation would be a really good thing to come out of this symposium. I next go to our final presenter, who is Mr. Philip Cross. He's an attorney at law with over 9 years of experience in planning and environmental law. He was formerly a legal officer at the National Environmental and Planning Agency and was the enforcement manager. He represented the agency in both civil and criminal proceedings. Presently, he's a prosecutor at the Integrity Commission. Philip, over to you. Thanks.
Okay, thank you, Carol. Right. Yeah, so I've been enjoying the presentations, and I'm glad that my presentation at the DPP was of some use, but I still learned a lot from Mr. Taylor's presentation and from the earlier presentations. So I will attempt to live up to the high bar that's already been set. So my presentation is on Jamaican environmental jurisprudence and how far it's reached, whether it's heading in the right direction or not. Ms. Excel, when she started, did refer to the fact that, in her view, there isn't enough environmental jurisprudence or public interest litigation in Jamaica, and I agree with that. But I do think, and I'm going to try and persuade you, that there is an agile and responsive legal system in Jamaica, as Professor Taylor suggested that we need. Now, before I go any further, I have to give a disclaimer. All of the views that I express are my own independent views. I'm not speaking on behalf of the Integrity Commission, where I'm currently employed, nor on behalf of NEPA, where I was formerly employed. And the views that I express don't necessarily represent views that would be held by the Integrity Commission or NEPA. So I wanted to start off with looking at what public interest litigation looks like on an international, at an international level, with one example. I don't want to go into too much detail. So in 2018, in April, there was this groundbreaking case called Future Generations and Ministry of the Environment. So Mrs. Mattis had mentioned in her presentation on the question of rights, the question of whether do the trees have rights and do rivers have rights. And she gave the example of Bolivia where they always refer to Mother Earth, and that's how they ground a lot of their legislation. But in Colombia, they have had precedents where they recognize nature as having its own rights. And the most recent of those cases is Future Generations and Ministry of the Environment. This case was brought by 25 young persons who were representative of various regions in Colombia, which were regarded as particularly vulnerable to climate change. And in the case, they highlighted their individual circumstances as to how climate change was impacting them. They challenged the government on its failure to take steps to curb deforestation of the Amazon, of the Colombian Amazon, which was inconsistent with their Paris Agreement commitments and their commitments under domestic policy. So as you would have heard already, the 2015 Paris Agreement was a global effort to take I shouldn't say one last shot, but to take another shot at really dealing with this climate crisis. But a lot of people might say, well, it's not really enforceable. The agreement doesn't have any teeth, but hidden in the agreement is it gives the power to public interest litigation to really use the commitments that states make and to hold those states accountable. And that's what was done in this case. So what was found was that despite the commitments that Colombia had made, both before the Paris Agreement and with their NDC, their nationally determined contribution, which is how each state commits to what it will do to contribute to reducing climate change. What it had done with deforestation was actually to increase it. So there was evidence that deforestation was increasing. And they also argued on an intergenerational basis. So not just the rights of the existing persons, but persons in the future, and that those persons also have the right to enjoy the environment. And I forgot to set my timer. Whoops, I think that's about 3 minutes. Yes, so the court, relying on an earlier precedent where they had actually done this before and recognized nature as having its own rights, I just wanted to read these two quotes from the judgment translated by the Justicia, which is an NGO in Colombia. The fundamental rights of life, health, the minimum subsistence, freedom, and human dignity are substantially linked and determined by the environment and the ecosystem. Without a healthy environment, subjects of law and sentient beings in general will not be able to survive, much less protect those rights for our children or for future generations. Therefore, in order to protect this ecosystem, vital for our global future, just as the Constitutional Court declared the Atrato River, the Colombian Amazon is recognized as a subject of rights, entitled to protection, conservation, maintenance, and restoration, led by the state and the territorial agencies. And following that judgment, they ordered the Colombian government to develop an intergenerational pact for the life of the Colombian Amazon, to formulate short, medium, and long-term plans to curb deforestation, as well as municipal plans which had to be adjusted in order to achieve a reduction in deforestation. And I'll get back to what's happened following this later on in the presentation. But that's just one very striking example of public interest litigation and its effectiveness overseas. But there have been several, and there's been a trend and an increase across the globe, and there have been different approaches. I won't discuss these in detail, but there's Urgenda and the Netherlands, where they similarly challenged the Netherlands on its commitments to reduce climate change. Lagar in Pakistan, which involved a farmer who was successful in, well, Urgenda was successful, and in Lagar in Pakistan, the farmer was successful in challenging the government for its climate commitments, given Pakistan's contribution to global warming. And Client Earth and the Secretary of State for the Environment, I think they recently had a Supreme Court ruling. So the first ruling was in 2015, and they essentially challenged the government on its efforts to meet its obligations under the Clean Air Directive, which is an EU-wide directive, which the government was committed to achieving. So it's not climate change per se, but it's the same concept. It's the same concept. And in each of these cases, they were successful. There have been several where they're not successful, but it just gives you an idea of what's out there in terms of international trends. Now, how have the Jamaican courts dealt with issues of public interest litigation and environmental litigation? I'd like to suggest that although there aren't that many cases on the issue, the cases that we do have do demonstrate a willingness of our courts to utilize the law and to apply the law, not necessarily judicial activism, but to apply the law in a way that provides meaningful protection for the environment and a meaningful avenue for litigants and persons affected to pursue justice. So I would refer to first generation cases or classical approaches. But before I do that, just briefly, I wanted to outline the permitting structure in Jamaica very briefly. So one, you require a permit typically to do large developments. So that requires planning permission. And if it's a prescribed category, it also requires an environmental permit. An environmental impact assessment may be requested as part of that decision-making process, but it's a discretion. And there have been cases where litigants have challenged the discretionary nature of the EIA to suggest that in certain circumstances, it is mandatory that they do so. But so far that argument has not been successful. And there may be other permit requirements as well. If the decision is, if the applicant isn't satisfied with the outcome of their application, they can appeal to a minister. And the minister, and that's an aggrieved person. An aggrieved person doesn't include an affected party. It only includes the person who has made an application, essentially. And the minister, on hearing that appeal, can either uphold it, refer it back to the decision maker, or vary the decision. And if persons, and this is anyone now, is dissatisfied with that outcome, they can litigate, whether by virtue of judicial review or now with our constitutional provisions. But the first generation cases were referred to earlier by Mrs. Mattis, what we refer to as the Pear Tree Bottom case, or the Northern Jamaica Coastal Conservation Association and the Jamaica Environment Trust and others against the NRCA and NEPA. And essentially, Pear Tree Bottom was an ecologically sensitive area, and developers had applied successfully to build a hotel there. There was an EIA, but the outcome was challenged. The decision to approve the permits were challenged. Now, this is before the constitutional amendment to the Charter of Rights, and in it, Justice Sykes, he went into great detail on Wensbury, which is essentially a grounds of judicial review, where you say that the decision was so irrational that no reasonable person could have come to that decision. So he spends a lot of time to clarify that distinction, a lot of very helpful analysis of the case. And he also goes into a lot of detail on the duty and the obligation to consult, which essentially, even though it may not be mandated by the statute, if it is done, it should be done properly. And with all of that, it was found that there had been flaws in the process. The consultation was flawed, and there were material considerations which had not been taken into account. Particularly, there was a report from the WRA and other things that weren't taken into account properly. And as a result, parts of the case were successful. And then there is the Palisados case, or JET, Jamaica Environment Trust, against NRCA and NEPA. Decided on similar grounds, but that case involved the airport road, the Palisados Road. There was a permit to approve a 2-lane highway, and then at some point it became a 4-lane highway, and there were various disputes. And again, it was found that the consultation process was flawed, and as a result, there were declaratory relief was granted there as well. So given these early approaches, you might ask, well, what's wrong with the classical approach? Clearly, if things aren't done properly, our courts can take the necessary action. Sorry. So this brings us to what I'm going to try to refer to as second generation cases, which take a rights-based approach to challenging government decisions. And the key driving force in my submission is that the new charter is what really allows for this to take place. And you've heard about it quite a bit this morning, but it speaks to the right to enjoy a healthy and productive environment free from the threat of injury or damage from environmental abuse and degradation of the ecological heritage. Now, those last words I will come back to later on, but you can essentially look at it as the right to clean and healthy environment. So in 2012, there was one of many Riverton fires. People start to refer to it as the annual Riverton fire. So it caught fire again, and it burnt for 6 days, covering 17 acres. which unleashed toxins among the Kingston population. Air quality was substantially impacted. And based on the Office of the Public Defender's report, the cost of putting out the fire was approximately 62 million. So persons who were directly affected by it brought a claim in 2014. But, and I'm not quite sure why it took so long for the hearing, because as you can see, it's a 2017 ruling, but essentially the NSWMA sought to strike out the case on procedural grounds. And this is bringing us to why the classical approach isn't necessarily able to achieve everything we might want it to. So essentially they argued that they couldn't bring a constitutional claim because the objections that they were raising were essentially nuisance and other torts that they would need to bring, negligence for failure to manage the landfill, but they couldn't bring, it was argued, a case under the Constitution. And it would be difficult for them to show from a purely judicial review standpoint how the mismanagement of like what decision could have caused this nightmare to take place. So they tried to strike out the case and end it before it even started. So this decision isn't actually for the case, but for the application to strike out. But Justice Lindo didn't agree with the submissions, and she highlights the shortcomings of the classical approach, which is that generally claims can only be brought for environmental harm where private parties' interests are involved, such as damages to their property. So for example, the law of nuisance, which was argued in the same Riverton case, you need to have a proprietary interest to be able to pursue that claim in tort. And a large proportion of the people affected would not have that claim. And if you refer to public nuisance, well, public nuisance is a criminal offense, and I won't get into that detail, but you can see the limitations of the tort, as well as negligence, proven causation, and everything else. Usually, based on the common law, it would be in those areas. So I am of the view, this is Justice Lindo, that the avenue for redress have been broadened. The provisions on the enforceable right to a healthy environment are clear, thereby recognizing a substantive right to healthy environment and also recognizing infringements on human rights through adverse environmental conditions. And then the Court of Appeal recently affirmed that position. And so now hopefully we will hear more about that case, but I couldn't say where it's reached now. Another case that's, I'll call it second generation, is the Dolphin Cove case. So this would have been also very widely circulated in the media. They also alleged constitutional breaches, but this is the case where they also argued that the EIA was mandatory. Now, leave for judicial review was denied on classical grounds, so they couldn't show where there had been a breach of natural justice, and they were also unable to show how their constitutional rights were impacted. The issue of the welfare of the dolphins was raised, but it wasn't argued. So there was evidence of it in the affidavit, but it wasn't actually pleaded. And so that didn't really play any significant role in the outcome. And then lastly is the Landilo decision. The Landilo decision. So this one involved the farm pen community, and there was an approval for a gas station that was in the farm pen community and would have affected Mr. Ashton Pitt, who was arguably the closest resident to the development. Now, again, this case was decided on classical grounds. They found that the public consultation process in this case was flawed. So there had been a community survey done by the developer, but it didn't seem to be representative of the community because I think only 9 participants responded, and Ashton Pitt wasn't one of them. He wasn't contacted. And then NEPA did a verification survey, and that was also not representative, only 7 respondents. And again, Mr. Ashton Pitt was not one of them. So what's interesting about this case, though, is that they do go into great detail on the normative content of each of the constitutional rights pleaded, including a right to a clean and healthy environment, which is the one I will refer to. So in exploring what that right entailed, the court examined the Banjul Charter, that's the African Charter of Human Rights, the European Convention on Human Rights, and the UN Convention on Economic, Social, and Cultural Rights. And they examined case law from the ECHR, and then this is this is the Nigerian case involving the Ogoni people and a dispute with Shell where toxins were released into the environment, and it's a very nasty situation. But a lot can be gleaned from that case as to what the right entails. Also interesting is that they challenged the they considered the constitutionality of the Town and Country Planning Act. And although the majority disagreed, Justice Bertram Linton did agree that the Town and Country Planning Act was unconstitutional to the extent that it didn't allow an interested third party a direct avenue to be heard. Now, third generation cases, well, returning to the Colombian case I mentioned at the beginning, since the ruling in 2018, the government has actually increased its deforestation efforts, and it hasn't produced the intergenerational pact. And so now the plaintiffs are actually going back to court to try and enforce these orders. And one might ask then, well, what was even the point of this? Why even bother with these extreme interpretations of the law, if you can call them that, if they're not enforceable? And so one academic, Slobodian, she, in discussing this case, she questions whether litigation is always the right tool to really achieve environmental justice. Rights of any kind are inherently a blunt instrument for addressing a highly technical, complex, and uncertain problem, as many courts have recognized in refusing to legislate from the bench. However, while the political process fails to take necessary action, the courts have become a last resort. And in that respect, I would say that our courts also seem very willing to examine just how far our charter can go in protecting environmental rights. And so I would just highlight these 3 points. Even though the decisions still tend to focus on classical grounds, they still remain important because procedural rights are key to ensuring that the decision-making process is fair and sensible. Courts are open to exploring environmental jurisprudence to find out, okay, I didn't quite finish that one, to find out what exactly each of these rights contains. What is the normative content? What does it mean? It's one thing to say you have a right to a clean and healthy environment, but it's another thing to actually adjudicate on it. And thirdly, the Charter provides avenues for, I would say, whatever we might call a third generation jurisprudence, because of its recognition of the ecological heritage as a constitutional right in and of itself, which actually goes beyond grounding every environmental claim in how an individual has suffered or can benefit. And so in that respect, I think that our courts are actually very willing to adjudicate on these issues. And so I think our laws is going in the right direction. And thank you.
Thank you very much, Philip. I think it was a really interesting presentation, and I liked your framing around different generations of cases. And thank you for bringing us up to date, not just with cases that are from the region, like Colombia, but also in depth on some of the cases that have come before the Jamaican courts and some of the grounds that have been used to bring them forward. I'd ask everyone who's interested to please put your questions in the chat. We have a couple of questions already, but maybe I would first ask that for all the panelists to put on their screen so we can see your lovely faces. Jeremy, also Professor. If you could, yes, wonderful. Thank you all for very interesting presentations. My first question, which maybe I will direct to whoever would like to take this on, and maybe Jeremy is probably the first person I'd like to direct this question to. You mentioned one of your last remarks was like if there was any challenge about whether or not the courts, the criminal cases were being brought before the courts, there is an avenue of private prosecution. I wonder if you could really reflect a little bit about that. Is it really feasible for private citizens to take cases under the fisheries, new Fisheries Act in Jamaica, both in terms of the kind of overload of cases in the court, but also maybe the risk that they take upon themselves if they try to take a fisheries case? And what ways do you think we could make it easier for the ordinary person to be able to take cases before the court, whether it's civil or criminal? Are there barriers that would make it really difficult, especially for vulnerable groups, to do that? What are your thoughts?
Well, I'm not sure I'll be able to answer the civil. Maybe Lalita can take on that part. Well, I threw out the whole thing of private prosecution because it is still there. It is still an avenue open to citizens. And we have seen it being used. It's used to some extent in the parish courts, for example. Your average breach of the Rent Restriction Act case is usually a private prosecution case. It's usually brought by the aggrieved party. But I do admit there will be some difficulties in terms of getting the scientific reports, in terms of getting the witness statements, in terms of serving summonses, that kind of thing. There will be an expense. But I threw it out to say that there is an alternative. If you believe that the state is moving too slow, if the police and the clerk of court or the DPP are not taking any action and moving at what you perceive as environmental breaches taking place before your eyes, I put it out there to say the citizen can actually initiate these prosecutions. And remember, the Constitution allows for the DPP to either take over these prosecutions. So a private prosecution may start, it may come to our attention, we may find that there is merit in it, and then we will come in and assist the citizen by taking it over and using the resources of the state in relation to advancing it. But these are private prosecutions with merit. There may be some without merit, and people are aggrieved if we throw them out. But it is an alternative for citizens to achieve justice through the criminal arena.
Thank you, Jeremy. Maybe I'll go to Philip and Lolita. Philip first, about the barriers that it takes for private citizens to be able to use both the new right to a healthy environment in the Constitution based on the reflection of the cases that you mentioned, and some of what you yourself experienced as someone who used the court system. What were some of the challenges you found in using the court system for environmental preservation of the environment and protection of the health of local people?
Should I go first? Oh, it was okay. Well, one of the challenges I think was actually for people to even believe that they had this constitutional right. I remember one of the first cases I had. One of the first cases I had when I was just called to the bar, and we were interviewing a witness. There was a pollution incident in a parish, I won't name it, but we were basically saying, he was talking about how much this pollution had impacted on him directly in terms of his livelihood, in terms of the stench in the area. And being junior at the bar, I was like, but you have a constitutional right. And he laughed at me, and he's like, those things are just on paper. They're not actually there to protect us. So I found that the biggest issue really is whether people actually believe that these rights will be enforced. And as a result, what you find is that the only people who pursue them are wealthy people, sometimes through the back end, because if you have let's say you have a proprietary interest, it's convenient to have an environmental interest tacked onto it. Not that there's anything wrong with doing that, but the only people who really are able to avail themselves of it are wealthy people or NGOs who are concerned about the ecological significance of a particular area.
Lolita, just turning to you, you mentioned the Escazú Agreement, which the government of Jamaica has signed but not yet ratified. Do you think that this agreement could improve access to the courts for ordinary citizens to be able to use the courts effectively?
Well, I think once we ratify, what ratification means, that we will have to implement the mechanisms to make it happen. I think, however, that one of the other ways we could look at it, we don't have it in the NRC Act, and I'm not sure if the Fisheries Act has it, perhaps I haven't read it for a while, but we know, for example, in Trinidad, if you receive a permit and you're in breach, which means that that's criminal, the citizen has the right to approach the regulatory agency and to ask for an investigation. The agency is obliged to investigate, but not obliged to take the action. But then it sets in motion the right of the citizen to pursue the action if the regulatory agency does not allow it. Of course, again, we know the issue of legal fees, etc., which is a determinant. Hence, when you look at the Escazú Agreement, we realize where the state will be mandated to ensure that systems are in place for persons to have access to justice, not just access to information, but access to justice. And I just want to point out here as well that Jeremy did raise the issue of the proof beyond reasonable doubt, but we also know that in some jurisdictions, the standard is being changed to balance of probabilities because of the nature of environmental offenses and the manner in which you treat them, whether you treat them as strictly criminal or whether you treat them as public welfare offenses, which kind of changes the balance here. So I think there are opportunities. I also want to mention the fact that remember that nuisances in our jurisdiction are now statutory. So you don't have to go by way of the court for a private or whether it's a public nuisance issue, but that under the public health regulations, you have the public health nuisance regulations, which define what a nuisance is and brings again into fore a series of mechanisms where the citizen can have action. Of course, you go to the Ministry of Health and you make a report, etc. But there are opportunities. I really believe also that we need to have greater level of agitation. Philip did mention the notion of persons not wanting to come forward or not being aware of their rights. We also need to understand that in our context and in many other contexts, the issue of coming forward also will have an implication on the complainant's economic reality, because many times persons who are being affected are also dependent on the polluter for their economic survival.
Thank you, Lolita. And there's a question in the chat for Professor Taylor. The person, Michelle Walker, says, Professor Taylor spoke of developing adaptive climate mechanisms suitable for this region. Don't these have to be supported internationally with funding and expertise? And what is the role for lawyers to ensure that we will have adaptive climate mechanisms in Jamaica?
Well, I'm not a lawyer, so not sure I can expand on all the roles for lawyers. But yes, I'm arguing that there are these needs for these adaptive climate mechanisms. And just to be, clear, they span the range of, kind of socioeconomic sectors. It's not just within the environmental sphere. One of the things that climate change, does is it actually is an opportunity as well for innovation and entrepreneurship. Probably I'll just zoom in on that area. And some of that innovation and entrepreneurship has to be very contextual. It has to, for a long time, we've been importing adaptation mechanisms. But then when it becomes contextual, when it becomes, out of the Caribbean and local environment, then there's a whole legal framework that I think governs entrepreneurship and innovation. And if I zone in just on that area, which, and I'm not sure that it is considering, those kinds of things. There are also other clear areas for this adaptation mechanisms. We need new mechanisms, for example, to deal with the kind of things like carbon markets that are emerging. And so there's a whole area for that, which I think is underdeveloped, but you can correct me on that. And there are whole other kinds of new adaptive mechanisms, risk and insurance and things for protection of the most vulnerable. And I think there, the argument I'm trying to make is that there are clear cases for interventions at the legal level. Some of this will require international funding and expertise, but quite a bit, a number of the responses really have to be contextual and have to emerge from within. Hoping I'm answering the question.
Yeah, no, just a follow-up question to you. Do you feel that we do have a policy and regulatory framework in Jamaica that addresses some of the needs? Because I know there's no climate law. Is one coming forth? Is that what would help us to act with more urgency to address some of the challenges, whether it be transportation, as you mentioned, the ocean, protected areas? I mean, how do we ensure that we have a vision of where we need to be?
I'm not sure if that question is for me.
It's for you, Professor. And Lolita maybe or can take it on after.
Right. Well, I learned a lot from the presentations here on what exactly exists, but I think what I left with, what's left with in the end is kind of where I started. There certainly isn't enough, but certainly it begins with first having a vision of exactly, really, when we're talking climate change, where do we, I think my challenge is sometimes when we talk climate change, we narrate significantly and we narrate purely to a protection of species or a protection of, and I'm trying to make this case that it's broader than that. It's your international law, it's your trade law, it's your environmental law. It's those kinds of things, all put together. Do we have the legal framework to address these? I think Philip was beginning to say we have some of this kind of framework. But certainly there is this need for what I'm calling this whole novel kind of law, which if you get the wider perspective of climate change, I'm not so sure that we have some of the things in place, but we will, rely on what's already in place. But Lalita, I think, is going to give the right answer.
But not necessarily. What I just wanted to say that even when you look at Prof. Taylor's presentation, I think the set of slides speak to what it is that the state ought to do. He actually spoke about, we saw a picture with like water harvesting. I really believe that we can use our environmental and our planning legislation to give effect to many of the things that we want to have affected. I recall too that when we just had a climate change ministry in Jamaica, they had a slogan with climate change, we must change. I actually started some research with climate change, we must change what? Because I think part of the climate change discussion has to do with, and I usually say it this way, when I get up every morning, what do I do? What do I need to do? What is my role in mitigating greenhouse gas emissions? What is my role in ensuring that we don't have sea level rise? Because these are really global issues. And we also know that countries like Jamaica, our contribution to global climate change is negligible compared to other large countries. At the end of the day, my presentation spoke to the right to development. If we are going to talk about eradicating poverty, at least alleviating poverty, what are we supposed to do? If we are supposed to provide housing, we saw the last heavy rains and what that has done. It simply means that some areas are no build zones. If we are expecting heavier, more frequent rainfalls, how do you deal with planning and development in this country? Professor Taylor spoke about using some of the interior. Those are, as he has said correctly so, those are our protected areas. Those are the areas in which we have our endemic species, our endangered species. So what is it? How do we bring all this dialogue to bear in a space that it makes sense going forward as a country? What do we actually do? Because there's so many competing forces. And if we really talk about sustainable development, what does that mean within the context of climate change? There's a question in the chat that asks what other convention, for example, speaks to the right to development. The Climate Change Convention in of itself talks about countries' sovereign right over their own resources and how to utilize them. That is tantamount to the right to development. You look at all these goals that every country is struggling to meet. Our 2030 goals, what do we do? How do we actually, is there such a thing as a balance? Or as the Grunter report said, it's a painful exercise in terms of how you do the balancing. And we have seen that in Jamaica. We have seen Falmouth with our cruise ship here. We removed so many corals. That's part of our coastal defense mechanism. We have to remove our mangrove. Professor Taylor also spoke about those are the natural defenses as opposed to seawalls. So I honestly believe that we are too small a country not to sit down at this stage and identify all our environmental issues with climate change, etc. What are we doing? How much more mangroves must we remove? Where are we going to put housing, etc.? I really believe that as a country, we ought to do what we need to do. And therefore, when the investors come, they already know that here are areas that are already red. Not red necessarily in terms of increased temperatures, but red almost like these are no-go zones.
Yes.
So,
thank you, Lalita, for those words. We are at time. I want to give each of our panelists just one or two sentences just to wrap up what they think their main message was before I thank you all for your contribution. So I'm going to just go quickly through each one of you, maybe starting with Philip, just any short last words, messages that you want to leave. Philip, yes, go ahead.
Oh, okay. Yes. So I would say that the key message is that times are changing. The environment, it looks more and more dire. It looks like Trump's going to leave the White House, and so we might get the U.S. back into the Paris Agreement. But the times are changing, and with it, so too does our jurisprudence also need to change. And I think that if persons are aware of their rights under the Constitution, under the ATI, Access to Information Act, ESCAZU, if we ratify it, then they will be equipped to hold our government accountable. And the government will know that what it has to do as well to ensure sustainable development.
Thank you. Jeremy, you next, just last words.
I think we need to stop legislating in silos. I think we need to take legal reform, especially in especially environmental offenses, seriously, especially in updating methods of evidence and penalties. And I think what works, we need to expand and improve on it.
Thank you. Lalita, last words.
just to say that the environment is common to all. As attorneys, I think the environment is our client, whether or not we are on the side of the prosecution or the defense, or whether or not we are a member of some vulnerable group. And I think if we all have that concept in mind, then we will all understand that outside of the environment, we cannot survive, but the environment will survive without us.
And Professor Michael Taylor?
Well, just to say that resilience is really the goal that we are going after. And, you know, to achieve resilience, we're going to have to figure out how to deal with the unfamiliar of the present while at the same time preparing for the unprecedented to come. But to do that, there's a role for everybody. And this was why it was great to be in this forum this morning.
So thank you very much, all my panelists. You were wonderful. And my understanding is that the presentations will be made available to those who are interested. On behalf of me and WRI, I also thank you for choosing me to chair the panel. I really loved Lolita's suggestion about the need for more wider dialogue in society about some of these issues, which are very hard and sometimes painful issues. In other countries, they're looking at other different types of participatory deliberation on climate, especially in the form of climate assemblies. Maybe it's time for something like that to happen in Jamaica, where we can hear all sides of the coin and make, very painful but important decisions. I want to pass it over now to Shazadi Ali, who has some messages. Thank you.
Oh, thank you, Carol. I just wanted to join you in thanking all the panelists for the excellent presentations. I mean, my mind has been open to so many new concepts and ideas on this really significant issue. So thank